Who appears for the state? Respondent? Acha, this is an appeal.
Appeal, Your Lordship.
Yes, yes. Who is for the appellant?
Appellant, I am.
No, no, you're not the appellant.
My Lord, District and Session Judge.
कौन सा केस दे रहे हो भाई?
District and
अच्छा, yes. Yes, which order?
My Lord, impugn order at page 18, Your Lordship.
अच्छा, you're appearing for the High Court.
My Lord.
Yes, what do you have to say?
My Lord, the relevant portion of the impugned judgment is lodged at page 28, Your Lordship.
Yes.
My Lord, the punishment order has been set aside on the ground that the disciplinary authority cannot pass the punishment order.
बोलिए, yes, बोलिए.
My Lord, and he may delegate the power to other districts and sessions to passing the order of punishment, Your Lordship. On this ground, Your Lordship, the punishment order has been set aside, Your Lordship.
Only for correspondence. कहता है कि doctrine of necessity something केवल चिट्ठी लिखा कि हम लोग नहीं, but जब you are the complainant, why did you pass an order? And why did you pass an order in hurry? यही हम पढ़ा। Yes.
My Lord. My Lord, Rule 17 of Bihar Civil Court Staff Rules 1998, Your Lordship. It provides, Your Lordship, the district judge shall be the disciplinary authority of the class 3 and class 4 employee. The district judge may suspend, initiate any disciplinary proceeding, issue a charge sheet, inquire into the charges against the delinquent employee himself, or cause the same to be done by
Civil Court Employees Rules दीजिएगा जो is referring. Yes.
1998.
चलिए pass करिए
My Lord.
We have followed that. So therefore, he is the disciplinary authority.
He can also pass the punishment order, Your Lordship, and he cannot delegate.
Not when he is the complainant. Not when he is saying that this clerk has misbehaved with him. Now he becomes a judge in his own cause.
My Lord.
No matter even if he was a district judge and he retired as High Court judge. We are in agreement with the single judge's order. Not on the merits of the case, but on the procedure. Now if I make a complaint against my secretary and I will decide that he needs to be thrown out. Which law tells you this? This is the basic.
My Lord.
In fact, if I make a complaint against my court master, I will never hear his case. Now, at least justice should be seen to be done, no? And we as judges can't derogate from all this. You have no ground, Mr. High Court.
My Lord, the power cannot.
Can you deny this? How do you say that the doctrine of necessity could not have been pressed into use? The man was proceeding for Patna to take oath as judge. What was the necessity of passing this order? It could have been given to any additional judge who has the powers of district judge.
My Lord.
I mean, I am not on the correctness of the decision. I am on the propriety.
My Lord.
No, therefore, I have given you my example. Not that I am speaking against any retired judge. But then if I make a complaint against my court master, do you think that it would appear to be proper that I take a decision and I throw him out of the service? He may be the most indisciplined and incompetent person. कहाँ है civil court rules?
1998.
All the laws have been thrown to the wind. क्या करना है? एक कप और निकाल के दीजिए. 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 एक कप और निकाल You are referring to section 17. आप अपनी बहस करिए, हमारे जोर से बोल देने से आप घबराइए नहीं. This is only a tentative observation. आप अगर कुछ दिखाएंगे तो करेंगे.
1998 your lordship, civil court staff rules
1998 rules. इसमें कौन सा प्रावधान दिखा रहे हैं?
18 your lordship.
लिखता है, अपने कर सकता है. District judge shall be the disciplinary authority. He may suspend, initiate any disciplinary proceeding, issue a charge sheet, inquire into the charges against the delinquent employees himself, or cause the same to be done. This is only when he is not the complainant. This is only. He can do it on the complaint of, say, a Siristadar. He can do it on the complaint of the registrar. But don't read a provision like this. Chiliye. All right. Heard, Mr. We are not even issuing notice. Heard Mr. Sanjeev Kumar, learned advocate for the High Court and High Court of Judicature at Patna, who has challenged the order dated 16/8/2018 passed by the learned single judge in CWJC number 16948 of 2007, whereby the order of punishment of the respondent of respondent number 5 of respondent number of the sole respondent dated 4/11/2006 has been set aside, and a direction has been issued and has been set aside. And has been set aside but has observed that such order shall not preclude the authorities. Such order shall not preclude the authorities from concluding the departmental proceeding in accordance with the conclude only the cut the nose. Has been set aside. Now, which disciplinary proceeding is to be concluded? It had been concluded. The matter has not been remitted. वो काट देना उसको. देखिए, the sole respondent was a clerk in the judgeship of Sitamarhi, who later rose to become Siristadar with senior selection grade. Had misbehaved with the then district judge of Sitamarhi. He was suspended on 15/2/2005 and a disciplinary proceeding was initiated against him with the charge that he procured illegal benefits from the encroachers in the court campus, and when he was asked to remove the encroachment, instead of following the orders, he proceeded on leave, and when the leave application was rejected by the concerned district judge, he visited the residence of the district judge with a request to permit him to go on leave. The further charge against the respondent is that he masqueraded illness. But before that, he exhibited uncharitable behavior which required to put him to departmental proceeding, as his conduct was unbefitting that of an employee of a civil court. From the order of the learned single judge, it appears that he took note of the fact that most of the accusations against the respondent were on the basis of the personal knowledge of the then district judge, who himself had initiated disciplinary proceedings and had framed charges against him. After the inquiry was conducted by the inquiry officer and a report was submitted, he himself recorded the punishment of dismissal of service. The learned single judge has taken note of the fact that the order in question was passed on 4/11/2006, when the then district judge had made an endorsement on the file that he was proceeding to join as judge of the High Court. Nonetheless, the appeal against the aforesaid order was also dismissed. The learned single judge, it appears to us, was absolutely justified in holding that the time-tested principle of natural justice, namely a man cannot be judge in his own cause, was flouted with impunity. And order of dismissal against the respondent was passed. He is referred to Bullapalli Nageshwar Rao and others versus Andhra Pradesh State Road Transport Corporation and other, 1984, 4 SCC 103. And has found that even with the aid of doctrine of necessity, and it was found that the concerned district judge ought to have applied the doctrine of necessity in getting the matter decided by another judge of the same rank, notwithstanding the provisions contained in section 18 of the Bihar Civil Court Staff (Class 3 and Class 4) Rules 1998. Next, be it noted that the aforesaid provision of the rules of 1998 declare that the district judge shall be the disciplinary authority of Class 3 and 4 employees, who could suspend, initiate any departmental proceeding, issue a charge sheet, inquire into the charges against the delinquent employees himself, or cause the same to be done by any other judicial officer, and impose any one of the penalties specified in Bihar and Orissa Subordinate Service Discipline and Appeal Rules 1935. The aforesaid rule vests the district judge of a sessions division with a power to suspend and initiate any disciplinary proceeding. Full stop. He could inquire into the charge himself and could impose any one of the penalties provided under the Bihar and Odisha Subordinate Services Discipline and Appeal Rules 1935. Full stop. This does not give a carte blanche, CARTEBL, to such district judge to decide in case of his own complaint against an erring official. There could be no more stark illustration of a judge of being a judge in his own